All right. So today I'm going to speak with you about a difficult, complex issue that is very much back in the news right now. And you will see from the title that I'm talking about abortion, and in particular, the question of whether or not recent developments in both the state of Texas and the Supreme Court mean that we are entering a new world in terms of both the constitutional law and the politics of abortion, what I would call a post Roe v. Wade world. And the question here is, for almost the last 50 years, since 1973, in one respect at least, the availability, the right at least, to an abortion has been the settled constitutional law of the land. The Supreme Court held in its landmark Roe v. Wade decision in 1973 that abortion needs to be made available to women in the first trimester of their pregnancy without regulation or impediment, that in the second trimester it was subject to some regulation, and in the third trimester it could be in fact made illegal, and that the states needed to put in place the details of laws that conform to that broad outline of rights. And that although it has been consistently challenged from the 1980s to the present, in certain respects scaled back by the court, this has been the operating assumption in all 50 states, and that the new legislation in Texas, similar legislation in probably a dozen other states, especially Mississippi, which will be coming to the Supreme Court this term as well, and the transformed composition of the federal judiciary all raise the question of whether or not the settlement of the last 50 years is about to be undone, and we're about to enter a different regime of rights, a situation in which there may be as many as half the states in the United States in which the access to abortion will be highly restricted or de facto unavailable. So we're seeing a preview of that in Texas right now. And I want to come at this issue from a variety of different perspectives. I'm going to start with a little bit of history and morality, thinking about this as a religious and ethical issue. And I want to be clear that convictions are both deep and complex on this issue. And I want to do my best to encourage us to be respectful of the complexity as well as the reasonable disagreement in this domain when it comes to both religious and moral conviction, but also to look at the politics of it and the way in which perhaps the politics of it, not surprisingly, are not adequate to the complexity of the moral and religious dimensions. And then come at it from yet a different angle, the constitutional law and constitutional politics of abortion. To be clear, right, on the one hand, there's a question about whether the US federal Constitution with its Bill of Rights should be correctly read as having implications for whether or not there's a right to privacy, a right to procreative freedom, and therefore perhaps a right to abortion, but also why the federal judiciary came to that conclusion nearly 50 years ago, or in a string of decisions that go back more than 50 years, and appears to be changing its mind, changing the interpretation of the Constitution and jurisprudence relevant to abortion, procreative freedom, and privacy in the third decade of the 21st century, and to tie the changes in the federal judiciary to another aspect of our politics. And this ties into the idea that our politics is not adequate to the moral and religious complexity of the issue, that in many ways abortion has become a culture war issue, that represents a political football that is tossed around for advantage and expediency to polarize and to cleave, as opposed to try to reach some form of agreement or compromise or clarity, at least about the principal differences. And so, as you can see, it's a difficult issue. I've got many different ways to come at it. I do want to spend some time thinking about Texas as well. So I will move somewhat quickly today through a thorny field. If you have questions, please, as always, just let me know. I won't be seeing your faces till the end, so just interject by unmuting yourself or raise your hand, whatever works better for you. Let's not spend a lot of time on this. I will just point out to you that new studies that have come out over the last couple of days suggest that the pandemic is probably going to, I shouldn't say the pandemic, the coronavirus is probably going to be a permanent feature of the health environment for the United States for the foreseeable future. And that doesn't mean we're going to be constantly in a pandemic, but it does reflect the fact that originally there was the aspiration in the public health community that through rapid and widespread immunization, we might be able to handle the coronavirus in the way that we handled the polio virus. In other words, to make it essentially non-transmittable in our society. And that the public health community has decided recently that that's impossible, that's out of reach. And that is because of the relatively low rate of vaccination and because of the slow pace of vaccination. And that, of course, reflects, as I've tried to argue with you in the past, the degree of our political polarization and the degree to which we became polarized over this issue. And maybe it's just good to have that in the background, right? If we're not going to come to consensus over what seems like a really clear-cut public health issue, how in the world are we ever going to reach agreement on a thorny, complex moral issue like abortion? The issues to do with voting rights will also be in the background today. I will suggest to you that Texas, where the legislation that is bringing this to national attention is enforced, that state is on the one hand, increasingly a multiracial and what's called in contemporary political parlance a purple state, a state where there's a roughly even divide between the two parties. And yet the way in which the state legislative districts have been carved up through partisan gerrymandering gives the Republican Party dominance, political dominance in the state legislature. And so the reason that we're getting a law that is, by the way, not only widely unpopular in the United States, but really quite unpopular in Texas, is because of one party dominance, despite rough partisan parity in terms of the actual population of the state. And so this reflects the growing prevalence of political strategies that attempt to tilt the way in which the political field is organized, the way in which districts are distributed, to give one party disproportionate dominance in closely divided states. I will just very quickly note that what we've been talking about for weeks past, the ambitious transformative agenda in front of Congress right now, does appear to be plugging along slowly but surely. I want to use Weber's phrase, the slow drilling of hard boards, to talk about what's going on in Congress right now. And so the debt ceiling crisis has been avoided, at least delayed for a few months. The Congress has funded the US government, so our federal employees continue to go to work and the checks continue to go out. And it does appear that there are behind closed doors, a lot of compromises being brokered and a lot of lobbying occurring. And so we will return to that. But for today, I really want to focus on Roe v. Wade and the Texas statute, formerly known as Senate Bill 8, which, as you may be aware, was held by a judge in an opinion on Wednesday, I believe it was, to be unconstitutional. That opinion was overturned yesterday by a district court panel and will go in front of the full district court maybe as soon as next week. They've given the Biden administration until Tuesday to respond to briefs submitted by the state of Texas. And so today, the Senate Bill 8 is in force in Texas. And you will be aware this is a novel, you might say unique and highly innovative piece of legislation. Not in what it does. What it does is essentially to try to make it impossible to get an abortion after 6 weeks, after fetal heartbeat is detected via ultrasound. Usually that occurs between 6 and 8 weeks. And it's worthwhile noting that given menstrual cycles, given the fact that many women don't keep track precisely of when they're due for their next menstruation or period, the 6-week time frame means that many women will not even be aware that they are pregnant before the law prohibits them from getting an abortion. Or to put it differently, let's say they're on the ball and they're aware at 5 weeks, that gives them 1 week to get all the medical clearances, to organize their finances, and to make the appointment and get the procedure. It is designed to make abortion nearly or effectively impossible. It also has no exceptions in the case of rape, in the case of incest, in the case in which it is an inviable pregnancy. The fetus has a congenital disease that will prevent it from becoming a healthy child. In the case in which the mother's life is endangered by the pregnancy, none of that is weighed. And so I think in the ways that Roe and its subsequent decisions have required a certain balancing in which the interests of the woman in health and procreative freedom, and even in the viability and health of her potential child, have been paid attention to, as the court has directed in previous laws. This law is not hitting that kind of balance. It is instead very unilaterally paying attention only to the absolute right of the newly conceived fetus to life. And then the second aspect of the law, the one that's drawn most of the attention, that is also unique and I want to say diabolically clever, is the enforcement mechanism, which is this statute does not criminalize abortion. It does not ask the state to prosecute abortion providers. It instead creates a civil liability for performing an abortion. And what that means is that you can be sued if you perform an abortion or if you assist in performing an abortion, where assisting is defined in very broad terms. Probably if you deliver medical supplies to a clinic that provides abortions, you can be sued as someone who has contributed to the performing of an abortion. You can be sued for $10,000 by anyone in the United States, and you can be sued in any court in the state of Texas, right? And so you might live in Dallas and be sued in Austin or vice versa. And if you lose that suit and the threshold of evidence required is very low, you are responsible not only for the $10,000 fine, but also for the legal fees of the person that has sued you. And I'd be willing to bet if abortion continues to be provided in Texas, which it almost certainly won't, 3/4 of the clinics are closed down. Planned Parenthood is closed down in Texas right now. If they decide to open up in order to fight this law, if this goes on for a while, there will probably be lawyers who set up shop just to sue abortion providers. There will no doubt be pro-life activists who are dedicated full-time to bringing these suits. And so there's a aspect of this legislation that in a sense deputizes ordinary citizens to enforce it. Vigilante might be a bit strong. It occurs within the confines of the law, but nevertheless, if we were looking to the value of civility, to the value of citizens getting along on respectful terms while trying to work through their complex religious and moral disagreements on an issue like abortion, we certainly would not create a law that allowed one side to sue the other side for a large amount of damages, and that casts the net very broadly. So when I speak of culture war politics, politics that is designed to inflame our differences in order to cleave us, to divide us, and then to put us into an us versus them frame of mind in which we are very different from and threatened by the other side. This is legislation that is almost surgical in the precision with which it's designed to do just that. And so this is culture war politics par excellence. Now, I'm going to shift, and I'll be shifting a lot in today's lecture. Like I said, please feel free to interrupt me. Not interrupt me, question me, should a question arise. But let me start with a little bit of historical, political, and philosophical background here. One of the people who I think does very interesting scholarship on this is Leslie Reagan of the University of North Carolina, who's written several historical books. The one I'm looking at, or I've shared with you on the slide, is Dangerous Pregnancies. She goes all the way back to ancient history, and it appears basically that abortion is at least as old as written history, which is to say that whether it's Mesopotamia or the Phoenicians or the ancient Greeks and Romans or the Jews, we have record of advice to women and couples on how to induce a miscarriage when a pregnancy isn't wanted, what substances are so-called abortifacient, induce abortion, and that even when we look at the history of the Catholic Church, that for most of its history, abortion was not considered to be sinful or against church law, that in fact, the desire of women to terminate pregnancies was permitted up until the point of so-called quickening, that is to the point where women felt the stirring of the fetus inside their body, could detect that it was beginning to move of its own accord. And as Reagan points out, that approach gave women a great deal of power, right? It was their own understanding of what was going on in their body that determined when abortion was and was not permitted. Of course, the technology, the medicine surrounding these procedures, not even procedures really, right? Drinking tea or taking certain substances was much less effective, much less efficient. But the entire thinking and approach about abortion differed really until the 19th century, when the law begins to focus on this question. We'll talk more about why abortion begins to become a legal issue, why it is that perhaps religious opinion begins to change on this doctrine and teachings as well. But before I do that, I want to mention another book, and this is Kristin Wuker's Abortion and the Politics of Motherhood. Wuker is a professor of political science at the University of California at San Diego. And in the 80s and 90s, as abortion was emerging as a partisan political issue in the United States, Wuker spent a lot of time with the both pro-life forces, who were very much coextensive at that point with evangelical Christians, who were mobilized really for the first time in a long time politically in support of the Republican Party, and with the so-called pro-choice forces, which in many ways took the baton from the feminist movement of the 70s, who had been arguing for, among other things, the Equal Rights Amendment. And many of those forces got channeled into pro-choice politics. And Wuker, when I say she spends a lot of time, she's a participant observer. She goes to the meetings, she goes to the rallies, she interviews the protagonists, and she comes away with a picture of the complexity of the views of the mainly women who are involved in these politics, that those who call themselves pro-life are rarely absolutists, that they understand that there are good arguments on the other side, that they understand that there are complex, difficult cases like the cases of rape, incest, or threats to the health of the fetus or the mother, that the people who are pro-choice do not necessarily believe that abortion is a good thing, may in fact believe that women who are not taking advantage of contraception that is available to them and using abortion as a kind of last ditch measure of contraception are subject to moral criticism, that they're not adequately taking account of the moral stakes or the offense that they're going to cause to their fellow citizens. So complexity on both sides, and that as these women's views get taken up by, first of all, political organizations and then the political parties, they get simplified and turned into uncompromising moral absolutes that fail to pay sufficient attention to the nuance, to the subtlety, to the acknowledgement of the other side that you get in the perspectives, the views, the ideas of the people who are actually engaged in these politics. I want to now pivot to the philosophy here, and I will point to just two of myriad books written on this topic, and neither one of these books is a book about abortion, right? They're broader books, but they deal with the issue of abortion. Judith Jarvis Thompson, a very important contemporary moral philosopher, her book, The Realm of Rights, essentially says, let's start from the strongest perspective. Let us concede that abortion is homicide, that you are killing another human being. Nevertheless, there's an argument to be made that it is justifiable in certain conditions, but that you have to weigh the fact that it is, in fact, at least as far as some are concerned, the taking of a human life that you are justifying. And just as if you were in a situation where somebody had abducted you and the only way you could escape was by harming them, the law allows you to harm others to protect yourself and preserve your rights. So, too, in the case of abortion, the law should allow this, but we have to acknowledge that some of us will justifiably regard this to be hurting or killing another, and we have to weigh that as well. And this then gets us to Amy Gutmann, who I've put up here, currently the president of the University of Pennsylvania, Dennis Thompson, formerly the provost of Harvard University, both leading political theorists. And the book I'm focusing on is The Spirit of Compromise, Why Governing Demands It and Campaigning Unmakes It, right? I think I've got the subtitle wrong, but it's so blurred I can't see that penultimate word. This is a book about deliberative democracy, and as far as they're concerned, deliberative democracy requires acknowledging legitimate and reasonable moral controversy when you encounter it, and then searching for ways of compromising. And they treat abortion precisely as a particularly difficult issue, one that really doesn't seem to admit of compromise. And they suggest alternative approaches to dealing with it, that if our religious and moral perspectives do not allow for us identifying common ground, then maybe we have to shift perspectives, find other ways of thinking about the question of abortion. And so both Gutmann and Thompson and Judith Jarvis Thompson are suggesting this is a complex, difficult moral and religious issue. It is one that may require us to acknowledge that in order to defend what we view as right, we are doing what others will reasonably regard to be wrong, and that at least in civil society, when we're having discussions among ourselves like we are today, as opposed to out on the campaign trail or trying to mobilize our church or other activists, we need to be attuned to the difficulty of this issue, to the reasonableness of the other side, to the idea that people of goodwill may genuinely and deeply disagree on this issue, and that it is unfortunate, it is difficult, but that doesn't mean that we need to treat it as the only or the single most important issue that we have to face together. That a politics that dwells obsessively on this issue is suspect from the outset as a politics that is trying to fracture and polarize us. And that once we recognize the reasonableness of the other side, the fact that they aren't just out to get us, they're not just baby killers or people who want to put the state's hands on our bodies in order to keep us from exercising our rights, we can begin to approach the issue with at least some goodwill, some integrity, some respect for the other side, and some hope of resolving things. That is, I would suggest, the kind of conversation you might have in, for instance, an interfaith dialogue group, or if it turns out that one of your relatives is on the other side of the issue from you. But one of the themes I will point to today is that it's very complicated, very difficult to translate that level of subtlety, nuance, respect, moral detail into everyday political discourse, especially when that discourse is carried by political parties and political parties are seeking strategic advantage, and especially in the current American context. Before I do that, I want to speak just a little bit about the legal dimensions of this issue, the constitutional law dimensions in the United States. And to do that, I'm going to point to only one author, Ronald Dworkin, the, I would say, most eminent and influential legal philosopher of the last 50 years. Dworkin is the author of a dozen books, and there are literally hundreds of books written about him. He taught at NYU and Oxford for most of his career, and his book on these issues is called Life's Dominion, an argument about abortion, euthanasia, and individual freedom. It is sweeping. It's not exclusively about abortion, but he does attempt to find a constitutional law framework for resolving the issue of abortion. So let me start first with a little bit of legal background here. And as many of you, I'm sure, are aware, the Roe v. Wade decision is not an isolated legal decision, right? It grows out of a body of prior decisions and into a further body of decisions. Perhaps most fundamental as a precursor to it is the Griswold v. Connecticut decision, in which the Supreme Court began to suggest that there is a constitutional right to privacy. The Griswold decision had to do with the availability of contraception in the aftermath of the invention of the pill. I'm smiling. I learned interesting things about the history of the pill when doing this research. I won't share that with you today, but I'll just point out to you that some people think that this might be the single most important technological advance of the 20th century in terms of the way in which it transformed sexual morality, extended procreative liberty, and perhaps brought population growth under control. But let's leave that all to one side. The Supreme Court was asked to consider a Connecticut statute that said you can't have access to the pill, right? It's interesting to think that in the early 1960s, Connecticut, which we think of now as being a pretty liberal state, had a law in the books that said women could not get access to contraception, right? And the Supreme Court said, well, women have a right to privacy. That right to privacy means that the decision about the use of contraception should be made by her on the basis of her conscience, perhaps in consultation with her husband or partner or mother or rabbi or priest or doctor, but it's not the state's business to reach into her domain of privacy and tell her what to do there. So the right to privacy extends to procreative freedom, deciding how you're going to handle your decisions about sex and sexuality and childbirth, and that this is fundamental to the individual's moral autonomy. Now, the challenge is that the notions being evoked here are nowhere to be found in the Constitution. Privacy, procreative freedom, autonomy. This is not the language that the Constitution speaks. And so the Warren Court in the Griswold decision, the Berger Court in the Roe v. Wade decision, attempted to extend the reasoning and the logic of the Constitution, to treat the Constitution as a living document. And in so doing, they suggested, right, why is it that the Constitution prohibits the government from housing soldiers in your home? Why is it that it demands that there be a warrant before you're subjected to a search and potential seizure of evidence? Why is it that you have a right to religion and a right to freedom of speech and a right to assembly, it's because in the 18th century, the small number of men who got together in Philadelphia and then in Congress were trying to protect privacy. And that if we recognize that that's the normative core of these various rights and ask ourselves, okay, we live in the 20th or the 21st century. What does it mean to protect privacy, and do the enumerated rights in the Constitution suffice? The courts of the 1960s and 1970s said no. We need to recognize that there is a penumbra to the Constitution, a shadow or a glow to the Constitution that is implied, if not explicitly stated, that we can't in good faith and consistency say that only these rights are necessary to protect privacy, freedom, and autonomy. We need further rights. And Ronald Dworkin in this book says that that decision was clearly correctly decided, but that the court perhaps didn't go far enough in making some distinctions. And so Dworkin is one of the main advocates of the doctrine of the living Constitution. He believes that the Constitution is a moral document. He's in favor of the moral reading, that it contains principles of justice, and that each judge's duty is to interpret those as the best conception of constitutional justice available to us now. And if judges do that, then they will not just maintain, but extend the Constitution as a living document. And so he is very much associated with the implicit political philosophy or jurisprudential thinking of the Warren and Burger courts. And he says one thing that he would add to the Roe v. Wade decision is the distinction between moral and legal personality. And so that when we think from a moral or religious perspective about what constitutes a person, what is the kind of being that deserves the rights that we give to human beings, that we do that from a perspective that we will reasonably disagree about. And that's because there are metaphysical issues at stake, especially when we think about this from a religious perspective. Very briefly, as you are aware, Catholic teaching on this, which has evolved, right? It wasn't always like this. I think it's worthwhile noting. But Catholic teaching of the modern period suggests that a zygote, right, a collection of maybe 20 cells in the human body is ensouled by God. That is to say, it's at that point, very soon after conception, that the soul of a future person inhabits that small collection of cells. And so that's when abortion becomes immoral and a sin. And in case you're wondering, there is no medical exam that will reveal when the soul enters the fetus's body, right? That's what makes this a metaphysical issue as opposed to a medical issue. And Dworkin says the Constitution stays away from those issues, right? It separates church and state. It does not want us to have a sectarian state. It does not want anyone to use the state to impose their religion on others. And if the only basis for resolving the question of moral personality is particular religious, metaphysical, moral perspectives, then we have to stay away from it. But we can decide together and come to consensus on the issue of who is a legal person entitled to rights that the state will enforce. And very simply and easily, that threshold can be drawn at who is a separate person, no longer in another person's body, but physically existing in their own right. And it gets more complicated than that, but that seems to be the threshold for assigning legal personality and hence legal constitutional rights to an individual. And so our Constitution gives us a very clean, neat answer to this in ways that our morality and religion may not. Now, I have to say, I don't think Dworkin's solution is entirely successful in the sense that it doesn't tell us why, when there's a conflict between our religious convictions and the legal constitutional doctrine of the state, that we should attach priority to the Constitution over our religion. But having said that, I think something like this approach shows us how we might, if we recognize the reasonableness of religious and moral controversy here, begin to approach this. And this leads then to a balancing of rights and interests, to the idea that women clearly have constitutional rights, that those constitutional rights include having some procreative freedom, some personal autonomy, some privacy, that the kind of statute that Texas has recently passed that basically assigns no value to the woman's liberty or health is failing to strike an appropriate balance and is therefore unconstitutional. Now, having said all of that, and having indicated that if we want to address this difficult issue with good faith, we need to recognize that there are real, deep, difficult issues that require us to respect the other side. And that on the other hand, constitutional norms do seem to be on the side of at least some right to abortion that should be legally protected. Then it particularly comes into focus that this has not been the approach of the so-called pro-life movement, and increasingly of the modern Republican Party, which have chosen really to focus on Roe and abortion as what I will call a culture war issue, right? An issue that helps them to assemble a coalition by pointing a finger at the other side and saying they are awful people. They are people who will murder innocents in order to preserve their liberty. And so that this is opposed to being resolved by intricate discourse in civil society or balancing of interests in constitutional law, become very much the stalking horse for contemporary conservative politics. And I want to say a little bit about how this has happened and why. And so I'm now drawing on, I've got the book somewhere around here, but I'm not seeing it at the moment. Here it is. Sorry. The book by Christopher Akins and Larry Bartels, Democracy for Realists, that I've spoken with you about a long time ago. And they focus on abortion politics and partisanship in abortion politics. And they're interested in a question, right? Do people have pre-existing strong issues, positions, and then choose the politicians and the parties that they want to support based on their independent views on the issues? Or do they have strong social identities, often partisan identities, and then take cues from the people who lead those identity groups, in the case of partisan identities, from the leaders of your party, about what issues people like you take and what position you take on those issues? And they argue that it's the latter. And so they argue that in the 1960s and 1970s, essentially abortion was not a partisan issue, that there were equal numbers of pro-choice and pro-life people as well as people who were on the fence about this issue in both parties, and that it's only in the late 1970s into the 1980s and 1990s when the Republicans really planted a flag in being pro-life, and then the Democrats defined themselves somewhat reactively against the Republicans as being pro-choice, that we began to see a shift in partisan views, and that it's the parties that drive the change, not people's underlying convictions. And so one way they attempt to demonstrate this is by looking at the difference between men and women who left the Republican Party over the position on abortion. And their suggestion is that women are more likely to have strong views, men are more likely to align themselves with the party. And this is what they find, that men who thought that abortion should always be available in 1982 stayed with the party through 1997, whereas women who thought it should be always available left the party. And then the other thing that they show, and this is, I think, the most interesting and convincing thing, is that the number of people switching from pro-life to pro-choice views was quite high in the Democratic Party and rather low in the Republican Party, especially for men. And this suggests that for many of us, we may not have deep religious or ethical convictions about abortion, but that in fact, this is primarily a marker of partisan identity. And that is a difficult line to draw. Who has a genuine religious conviction? Whose conviction merely reflects the way in which their political identity leans, right? And I'm not going to suggest that we can mark that distinction clearly, but I am going to suggest that there's something illuminating about the way in which abortion is being used in contemporary politics if we notice these trends in public opinion. So having said that, I now want to drill down on why it is that the Republican Party found becoming the party of pro-life to be a successful strategy. The political entrepreneurs within the Republican Party found this to be a good way to mobilize voters and to create a clean divide between them and the Democrats, to peel off a certain number of voters on their side. Or alternatively, why Democrats found that becoming the pro-choice party was advantageous for them. And this diagram I've shown you before, it's got me refresh your memory. This is my diagram, but based on Emile Durkheim's sociology, especially the book Suicide from the late 19th century. And in that book, Durkheim suggests every society provides a certain kind of normative scaffolding that helps its citizens to determine what is allowed by them and what is expected of them, right? And some of this has to do with moral regulation. What is allowed, what isn't allowed? How attentive can you be to your material interests, for instance, right? For a long period in Catholic history, greed was seen to be a sin, right? And much less so recently, right? As well as social integration, which means how much the role that you're assigned by society carries concrete and specific expectations with it. And here I think gender norms are the most important dimension of this for today's conversation. Does being born a boy or a girl, becoming a man or a woman, determine important aspects of the duties, responsibilities, roles you're going to play within your society? And to be clear about this diagram, Durkheim says there's such a thing as too much social integration and moral regulation, that it leaves too little room for people as individuals to determine what they want to do with their lives, what makes them happy. But there's also such a thing as too little, and that leaves people feeling unmoored, adrift, disoriented. And his concern was that modern society was moving in the direction of too little integration and regulation of individuals, that anomie and egoism were characteristic modern forms of malaise. And again, another diagram that I've shared with you before, but I want to refresh your memory on in the context of today's lecture, suggests that we're perhaps experiencing a reorientation in modern American democratic politics, that the old orientation of the 20th century, which was a left-right orientation. Either you were in favor of a relatively strong federal government that taxed a lot, that used its resources to redistribute income and wealth from the rich to the poor, to create a strong social safety net to regulate businesses and other private actors, or you were in favor of a relatively confined, small central government that didn't play many of those roles, that taxed less and left people on their own, or depended upon churches and other civil society organizations if things didn't work out well for them. That this was a central way in which our political parties and our politics was organized. And the research of a lot of different political psychologists over the last 20, 25 years suggests that that framework is increasingly being displaced, or at least complemented, by a second framework, which has much more to do with those issues of anomie and egoism, of being at sea and disoriented. I'll give you a funny example. I got an email a couple days ago from the New York Public Library. We aren't imposing fines on late books anymore. And I was talking with someone and they said, oh my God, the sky is falling. The library is not even imposing fines anymore. And I think that's a funny, light example of a deeper issue, which is that so much of what we expected based on the traditions and conventions, the morals of America 50 or 100 years ago, is no longer being carried into the future by current generations. And there are some of us, and again, right, this is familiar, I hope, who might be called cosmopolitans, who are open to this change, who welcome it, who say there's more liberty, there's more freedom. Those old norms and expectations were oppressive. What if I didn't want to be a traditional breadwinner just because I'm a man? What if I wanted to be a stay-home dad? What if I wanted to be a worker or a professional or a political leader, and that was not available to me just because I was born a woman? That's unfair, and we're in a better world as a result of having become more open to change. But there are also people in our midst, and I want to say there's roughly equal shares of these two groups, based on what I'm seeing from the research, who say this is happening way too fast. And this is scary and disorienting. It may, in fact, be leading to decline or nihilism. We need a strong leader to stop this pace of change. We need to close our society to some of these forces, whether those forces are cultural forces that are undoing gender, or those forces are literally demographic, that are making us a much more diverse democracy. We need somebody to stop this, hit the brakes, and maybe even take us backwards, right? And what the issue of abortion has allowed the Republican Party to do is to signal that they're on this side of the divide, right? In a sense, if you're on the libertarian side of the divide, you might be pro-choice, right? But if you are instead more interested in signaling to your voters that we think that the rate and degree of cultural change that our society is experiencing is too fast and too deep and needs to be slowed and reversed, abortion is a very good issue for doing that. And similarly for the Democrats, being pro-choice is a very good way of signaling where they are on the top-down spectrum, not the left-right spectrum. And so then let me just note a little bit of evidence and a little bit of the complexity surrounding this way of thinking about the issue. And the evidence comes from going all the way back to that first slide with the books I showed you, Reagan's work on the history of abortion and her finding that there's a fairly tight correlation in American history between women becoming politically active as abolitionists in the middle of the 19th century, as suffragettes, and then as prohibitionists later on in the 19th and 20th centuries. And so women become politically active, start making demands, including the demands for the vote and full equal citizenship. And as that happens, more or less shadowing that, following that very closely, are demands for increased political regulation of women's sexuality, right? And Reagan is very clear. She does not think this is a coincidence. She thinks this is a reaction. This is an effort to, if you will, re-domesticate women. And so that might be in part pure gender politics. It might also be in part symbolic politics. Those who want more order, slower change, greater tradition will like the fact that one party is sponsoring laws that try to regulate women's sexuality in order, in essence, to keep them in the domestic sphere. And I want to add to that, that this becomes particularly difficult, particularly fraught, as we become more and more what sociologists call a post-traditional society, right? And to take another example of what this means, I will point out to you that the majority of Americans today marry across denominational bounds. This is new. This is unprecedented in American history, that we don't marry within the same religious denomination. And as a result of that, roughly half of us switch denominations or religions over the course of our lives. And while some of that may be shifts within Protestant denominations, some of it is actually shifts across religions, right? So you go from being Protestant to Catholic, or from Protestant to Jewish or Buddhist, right? And so this is an indication that whereas in a traditional society, one essentially reproduces or replicates the tradition of one's parents, where religion is clearly one of those central traditions. In a post-traditional society, we do not consider ourselves to be bound by what our parents did. We consider ourselves to have the freedom and autonomy to change religions, to abandon religion, to create our own hybridic religions, to change our gender, to change our sexuality, to change the way in which we perform our gender and our sexuality. And that all of that is wonderfully liberating for roughly a third of us, and terribly confusing and threatening for another third of us. And for those people for whom it's a threat, they want to reimpose tradition. But it's one thing for a tradition to maintain itself organically through the voluntary choices or the identifications, or even through perhaps social but not political coercion of individuals. It's a very different thing for the state to be in the business of trying to reimpose traditions that have lost some of their naturalness and persuasive force for those who must adhere to their norms. And I think part of the fractiousness of contemporary American politics reflects the fact that we have a substantial portion of our population, not a majority, who wants to reimpose tradition, and a major political party that has decided its best approach to winning elections is to become the vehicle for that demand. And that the Republican Party is doing this in ways that probably exaggerate the power and influence of these neo-traditionalists. I'm not going to be able to cover everything I wanted to cover with you today, but I do want to spend a few minutes flying through one more aspect of this, and that's to talk for a few minutes about the Supreme Court on the one hand and Texas on the other. And so I will note to you very quickly, right? The Supreme Court has become much more conservative, as has the entire federal judiciary over the last decade, and especially just the last few years as a result of Ruth Bader Ginsburg being replaced by Amy Coney Barrett. It's one of the most radical shifts in terms of the judicial ideology of the last 60 years, right? Comparable to Warren being replaced by Berger or Marshall being replaced by Thomas. That we see this already in the voting patterns, right? Barrett is voting most of the time with Alito, Thomas, and Gorsuch, the most conservative members of the court. We recognize that this is the reason that Amy Coney Barrett was chosen to succeed Ruth Bader Ginsburg. She was the most conservative member of the Seventh Circuit, a relatively conservative circuit. And we recognize that the Supreme Court is increasingly out of step with popular opinion, whether it's on Roe v. Wade, which 62% of people in this country want to leave and only half that number want to revisit, whether it's to do with abortion, where 33% want it to be always legal, and another basically 30% want it to be legal with only some limitations. That most people in the United States, as well as most people in Texas, disapprove of the Texas statute. And that brings me to the final question here. And that is, why is such an unpopular law being passed? And why is it perhaps likely to be upheld by the Supreme Court? And in particular, why is it being passed in Texas? Because despite some of our stereotypes, Texas is actually in the middle of a transformation, right? It's entirely conceivable that Beto O'Rourke will be the next senator from Texas. Texas is increasingly a purple state, not a red state. Texas now has roughly equal numbers of whites and Latinos, and it is clearly a majority minority state, right? And so what's going on in Texas? And please note again, I know the Republican Party is primarily a white party. The Democratic Party is a party that should be poised to do much better in a state with Texas's demographics. So what's going on in Texas? We know what's going on in Texas. It's that there is complete partisan control over the districting process. And then this shows the congressional districts. I couldn't find a clean map for the state level districts, but this is true at the state level as well as the congressional level. And so Republicans in 2010, and again now in 2020 in the aftermath of the census, have drawn the lines in Texas. The Republican Party, which was in control of Texas in 2010 with Tom DeLay, the Republican Party, which is in control of Texas in 2020 with Greg Abbott, is drawing the lines to basically bring about one party dominance, despite the fact that the population has almost partisan parity, and that this is not a successful long-term political strategy. It is clearly tilting the playing field in an incredibly unfair and undemocratic way, and it is effectively limiting the political power of nearly half of your state, and especially of people of color. How do you sustain that? How do you get away with that? And this is where it seems to me, we can look again at how gerrymandering works, but I wanted to call your attention to something that was written in the New York Times a few days ago. I'm sorry, the name of the author escapes me at the moment, but he concluded this essay about Texas politics by saying, Governor Greg Abbott and the Republican Party have embraced a top-down policy agenda that is backward looking, right? Trying to restore the old norms and the old Texas, as opposed to allowing Texas to come to reflect its changed demographics and partisan balance. Excludes huge swaths of Texas's citizenry and runs against the grain of many of its new stakeholders' values. They are looking to shore it up by a combination of gerrymandering, voter suppression, and relentless cultural warfare. As long as Texas continues to grow, they see no downside to it. But it seems to me and many other Texans that they are making a fatal miscalculation. And what I want to focus on is that connection between gerrymandering and cultural warfare. If you're going to try to win political power as a minority by slicing up the political map in a clearly tendentious way, and then really mobilizing your voters to vote, you've got to inspire a sense of moral panic in them, right? That's the way you get to justify this otherwise so clearly undemocratic and unfair approach to winning. And abortion is a critical part of the playbook that allows the Republican Party to suggest that sense of moral panic to its voters. I will stop there. I know I threw a ton at you today. Who wants to start us out with a question or a comment? You're there, right?
I'm here.
Okay, I wanted to make sure. When I hear complete silence from you guys, I think something must be wrong.
No, I'm here. I have there's an argument that if Roe v. Wade had never passed the Supreme Court, we'd be better off now than we are. In that states, one by one, states were liberalizing abortion rights. There are a bunch of states that wouldn't have, certainly, but they're not allowing a lot of abortions today anyway. And we could have, removed that particular weapon from the quiver of the far right, where it's been very effective for them. So there's something to be said for that. There's a problem, when the Supreme Court gets a little bit out of ahead of public opinion, it can run into trouble. And there's an argument that in this case they did. I don't know if I agree with that or not. It's an interesting point.
Yeah, and I don't know if you can see, I'm looking for a citation while you're making this point, because there's a book that I was just looking at. Let me get it for you. That I think is exactly relevant on this point. Maybe I'm not going to be able to get it for you. I'll have to come back with you about this. But it's a book about judicial politics and the limits of the court in driving opinion change. And I want to say two things about that. One of them is that there is a question of constitutional law here, right? And so you might say that affording equal rights to religious minorities is currently politically controversial. And if the Supreme Court decides to do that, then it's going to foment further controversy. Just let it play out through politics. And most of us would say, no, it's in the Constitution for a reason. The Constitution defines the preconditions for full political equality and the rights necessary for our society to call itself a democracy. And you can't let democracy override those rights, right? So that would be one thing that you might say. If you feel that Roe v. Wade was correctly decided, and that the right to procreative freedom is essential to women's autonomy and equality, then on what grounds are you saying, well, we should let their rights be violated because it was bad for the Democrats or good for the Republicans, or it arrested the natural course of democratic politics? I think you got to be careful in making that argument. The second thing I would say is it's just an interesting supposition, right? That we were headed in one direction, and Roe v. Wade was an inflection point, and it pushed us in a different direction. I'm not as confident, maybe, as some of the people who maintain that position that that's true. It seems to me we might not have polarized on the issue of abortion per se, but we would most likely have polarized around similar issues to do with women's role in our society, freedom and equality, that it's not just the one Supreme Court decision. The final thing I guess I want to say, and this goes back to what happens if the Supreme Court either overturns or guts Roe v. Wade in the coming session or sessions. And that's a whole train of connected decisions, from decisions about contraception to decisions about sodomy to decisions about gay marriage, right? And so we can't just surgically excise this one decision. If this decision weren't there, or if it gets overturned, a whole bunch of connected decisions are also in question. Does that make sense, John? And I don't fully disagree with the underlying analysis, but I think it's more complicated. Anybody else with a question for today? Elizabeth, you're pulling off your safety goggles. Go ahead.
Yes. The idea that the law should be moral is interesting. There are plenty of clearly immoral things that are not against the law. And nobody seems to, or let's say, we don't always make much fuss about them. And Republicans in particular don't seem to make much fuss about them. The other item is that this is somehow a Christian society, and should be a Christian or Judeo-Christian society. And, it's clearly not particularly, but if you look at the Bible, it does not address many of these issues. In Jesus' time, the Romans had their own system. They had lots of abortions. They had a lot of infanticide. When a Roman baby was born, the mother presented it to the father, and the father could determine whether it would live or die.
Yeah.
If he didn't like that baby, it went out on the to freeze to death. The lucky ones were picked up by the slave dealers to be raised as slaves. A lot of them died.
And
And there's no mention.
Roman slavery was not as bad as chattel slavery, but that's an interesting definition of luck, right? Let me focus for a second on the moral / religious dimension to this. And part of the issue here, of course, is that there are plenty of things that each of our religions, if we are religious, tell us to do that we don't ask the state to enforce, right? And so we believe in the separation of church and state. We believe in religious liberty. We believe in allowing, therefore, people to have different religious systems without asking the state to enforce them, recognizing that that's a recipe for civil war. The problem here is when your religion tells you that something is absolutely morally wrong. And so let's just think about it for a moment. If the requirement on participating in public debate is that you check your religion at the door, right? And if you're not religious or only loosely religious, or you don't get your political values from your religion, that's an easy requirement to meet. But if you're deeply religious and some of your political values are directly informed by your religious values, that's a harder standard to meet. And so I do think perhaps some of the reason I would say, back to John, something like this might have come to the fore anyway, is in part because of the perception that the United States over the last 70 years has become a much more secular society, and that is imposing unfair burdens on some citizens whose faith remains politically relevant to them. And again, one of the things I constantly counsel is that we be as generous and sympathetic to those with whom we disagree as possible. I think we have to concede that this, not at the level of partisan politics, but at the level of sincere belief, is genuine, right? That there's a genuine perception of unfairness, of asymmetrical burdens, that secular discourse comes easily for those who are not that religious or serious, or who draw compartments around their religion. That's a Sunday or a Saturday thing, as opposed to those who have a more encompassing kind of faith. Jeanette, yep, I see you. Go ahead.
Okay, why do we assume that the Catholic Church's definition of the zygote being the thing? My parents felt that it was morally wrong to bring children into the world if you could not care for them. And they used birth control at a time when in many states it would have been illegal. They were lucky enough to be in a state that would. But it seems to me there's a certain freedom of religion here that we're accepting some churches' definition of when abortion is illegal. And I think there are many situations where I could see somebody having this feeling it's immoral for me to bring this child into the world.
Yeah. And Jeanette, thank you for the comment. You broke up a little. Were you done?
A better way to prevent abortion would be a better support system.
Yeah, thank you for the comment, and I recognize that.
Prevent more allowance, more abortions than legal things.
Yeah, and it's interesting that I was listening to somebody speak on this recently, and they pointed out that you could try to create policies that would be as friendly as possible to childbirth, right? So to give women considerable support and rights who might want to bring children into the world, but who feel that they might not be able to discharge the duties that would be incumbent upon them as mothers. So greater support for children in general, financial support, healthcare support, educational and childcare support, etc. Right? Certain rights for family or maternal leave, right? Parental leave. And this person points out, Texas does none of that, right? As a matter of fact, Texas is perhaps the least pro-childbirth state in the country, if you were to look at all of those policies that might encourage women who want to bring a child into the world but feel certain reservations about it. And so this underlines the suspicion that Texas is not pursuing the deep religious and moral convictions of its citizens, that the Texas Republican Party is looking for a wedge issue, is looking for a cultural warfare issue, is looking to generate moral panic and to put its conservative religious bona fides front and center, right? And so I completely agree with all of that. I also agree that we have to be careful in allowing any one religion to impose its doctrine on us in the form of law, right? And that's, you know, the reason we have separation of church and state. The reason is that we don't want to be a sectarian society, that is incompatible with democracy and with the equal rights of a diverse citizenry. Having said all of that, I just want to note two things. The first is that it is possible and interesting that somebody could be pro-life for philosophical or ethical as opposed to religious reasons, right? And so we've got to take that seriously. And second, that this is a genuinely dilemmatic issue, right? Where protecting women's procreative freedom carries with it the implication that the way you do that is by letting innocents be killed, letting homicide occur if you believe that that's what's occurring. And I'll just give you an analogy with the law, right? And so another case in American history where a group on religious grounds said, those are legal persons, that group that you currently consider not to be human, we consider to be human, right? And it's because of our Christian faith. That was the abolitionist movement, who said that about slaves who were held as chattel property, right? And who were regarded by their owners as subhuman, right? As not deserving constitutional personality. And yeah, I think it's important to notice that religious conviction was essential to abolitionist success, right? And so I think we have to be careful in saying it's religious, therefore I'm not going to listen to it, right? Doesn't mean we want it imposed through law on the rest of us. But I think we do have to recognize that sometimes people's religious convictions help us to see things that we might not see from a purely secular perspective. And we want them to be able to participate as full equals and to be able to share their insights with us. And once we do that, then we've got to recognize, wow, this is a difficult, complex, hard problem. Having said all of that, the solution is clearly not to deputize citizens to fine providers $10,000, right? This is not a defense of the Texas statute. It is a plea for some generosity and attention to complexity in dealing with a complicated moral and religious issue that has, unfortunately, unavoidable political, legal ramifications. I think that might be a good place to leave off. And I know
Thank you, David. Thank you.
Thank you.
And I will very much
Next
look
week.
forward to seeing all of you in person next week. Take care, everybody.
Bye-bye. Thank you.
Guys. Be well.
Thank you,
Bye-bye.
David.
Thank you. See you next
Thank
week.
you, guys. Bye-bye, guys.